of that Insurance Act. That is why Supreme Court has given what is the concept of a nominee. So therefore, if he receives the property as a nominee, he can't use it for himself. And if he is doing it, if he is spending for himself, he is trying to alienate another member of the joint family, he can file a suit for not only partition but also permanent injunction to enforce that obligation again which is coming. Because the dependent has received the property as only a trustee in that full case. And the last aspect is that, well, a permanent injunction may be granted. Wording is everywhere may be granted because it is a discretionary relief. Where not a granting of permanent injunction will ultimately create multiplicity of the judicial proceeding, multiplicity of the litigation. For example, suit for partition has been filed. Suit for possession is filed. And suppose during the pendency, permanent injunction is asked. Similarly, on the basis of temporary injunction can be granted. If the karta is trying to dispose of the property or tenant is, that is lessee, is trying to create third party interest, certainly permanent injunction, because what will happen? When the suit is filed by A against B for possession and not to alienate property or not to transfer the property or create third party interest, if no injunction, during the pendency, B will transfer it to C. C will transfer it to D. And every time, the job of the plaintiff is to bring the purchasers on record. You know that well in Ramayana, you must know that. Ravana had 10 moons, you know that well. And in Lord Khandova was given assigned a duty of shaving. So when he used to shave the first mouth, goes on completing 10th mouth, that time first mouth again ready for shaving. And entire job was only that. Khandova said to the Indra, let us change my duty now, said that well. Because my only job is there only that well. Similarly, plaintiff will have to do what every time? Only to bring. I remember that suit older and older. I have filed one suit in 1986. For some reason, the suit could not be heard. Now recently issues are framed, even before 2 years back, but still suit is not conducting. Every time, defendant 1 died. Moment I bring the legal order, pursuits come, defendant 4 died. After his legal aids are bought, they say, that person who is brought as a legal heir, he has died. See, this goes on. So therefore, that is what we talk about. The multiplicity of the litigation is to be avoided. That does not mean, my friends, in each and every case, injunction is to be granted. Otherwise, everybody will claim the injunction on that ground. Depending upon the other part, but that is one of the criteria, also along with other criteria. Everybody followed the concept of the permanent injunction under Section 38? Friends, should we proceed further? Yes, this is what the aspect is. Now, my friends, as regards what we talk about, the permanent injunction, and I told you that, well, in which cases it cannot be granted, etc., etc. Of course, during my whole lecture, I will be every time pointing out to that, well, in which case is granted, in which case cannot be granted. Then let us go to the temporary injunction. Because I told you that, well, prohibitory order, permanent injunction, perpetual injunction. That we have seen only by way of a decree, only by way of at the end of the suit, at the end of the trial. A temporary injunction, which I told you, the object is to preserve the property, to maintain the status quo between the parties, that is during the pendency of the suit. Now, on which basis the temporary injunction is granted? Several aspects, my friend. The temporary injunction is to be considered on several aspects. And what is the source of the power to grant a temporary injunction? What is the source of the power? When the court has to grant a temporary injunction, whether Order 39 is the only source? No. What is the source? No doubt Section 38 And what is the another source? Section 94 of the Civil Procedure Code. If you see the provisions of Section 94 of the Civil Procedure Code, it talks about interlocutory matter. And wording is, in order to prevent the ends of justice being defeated, the court may ask a security, that is clause A, B, grant a temporary injunction, C, appoint a receiver, and D, grant an attachment before judgment. So these are the interlocutory matters as considered under Section 94. The importance of Section 94 is that where criteria is, in order to prevent the ends of justice being defeated, read with Order 39, court has got power to grant a temporary injunction during the pendency of the suit. We are not considering at these attachment before judgment, appointment of receiver, though they are interlocutory matters. We are only concerned with clause number B of Section 94. So therefore, in that particular case, my friends, we say that, well, a temporary injunction, the source of power. Now the wording is in that particular case, there is a lot of, if you read it as a particular interesting matter, that itself contemplates Section 38 is not also a source of power. It is a source of power, no doubt. But if you read the particular decisions, and if I remember correctly, 1962 Supreme Court, page 527, even the court has gone to the extent of saying the matters not covered under the Order 39 or Section 94, the court has got power to grant a temporary injunction even under Section 151. Matters not covered under the Order 39. Because Order 39, three clauses, A, B and C, contemplates in which cases temporary injunction can be granted, court cannot go beyond that. But take example, a particular matter is not covered under this clause A, B and C. Whether court is powerless? Answer is no. Court can certainly grant a temporary injunction under Section 151 of this Civil Procedure Code. That is what we talk inherent powers. Now the three particular clauses, so far as Order 39 Rule 1 is concerned, and that is called, first is that, well, Order 39 Rule 1. If property in question is being in danger of wasted, damaged, or alienated, or wrongfully sold in the execution of a decree. Second, property is being sold illegally to defraud the creditors. If the defendant is trying to sell the property for defraud the creditors. And C, if the defendant is trying to disturb the possession of the plaintiff. My friends, each clause is different. Before we consider this, or I will tell you one by one, and then I will tell you. Under Order 39, even defendant can make an application for injunction. In a suit filed by the plaintiff, but not under all the clauses. We'll see that. First, see, we say that, well, let us have a particular example. What is the meaning of it that well? That the property in question, that is what we always talk, suit property, described in the particular paragraph or a schedule. Property in question is being damaged or wasted or trying to be illegally sold, that is alienated, or wrongfully sold in execution of a decree. Even in case of execution of a decree, injunction can be granted. Now, what is the concept of being damaged or wasted? Take example, a lessor has let out the property to the lessee for the purposes of carrying out only a hair cutting salon. Not much damage to the property, that is all a sudden. One day, one fine morning, that saloon wala, that is the lessee, tries to change the nature of the property, in a sense, start renovations, even removing girdles, etc. And he wants to carry out a construction and use the property for the purposes of hotel, etc., etc. Plaintiff runs to the court of law, saying that the property was let out as per the agreement only for the purposes of carrying out the shop or business of haircutting salon. He is using it for the now, it appears, for the purposes of hotel, etc., etc., changing, damaging the nature of the property. When that is going on, whether it is empowered, court is empowered to grant an injunction or not. Yes, permanent injunction, ultimately, so on the lines of that, temporary injunction in that case. So my friends, therefore, you have to point, I remember a case, I am not joking, तुम्ही असं म्हणाल, पुण्याचे लोक आणखीन काही काही भारी आहेत, आधीच पुण्याबद्दल फार गैरसमज आहेत. टेनंटला एका जागा दिली होती, प्रिमायसेस वॉज लेट आउट. काही दिवसांनी त्याला सोडायची होती जागा, रात्री उठून फरशीला भोकं पाडायचा तो. आय एम नॉट जोकिंग माय फ्रेंड्स. ए क्लायंट केम टू मी, दॅट पर्टिक्युलर लँडलॉर्ड केम टू मी. काही फरशा उखडायचा, काय आपण म्हणाल वेळा आहे का, असेल सुद्धा वेळा असेल. वी फाइल अ सूट अगेन्स्ट हिम, नॉट ओनली फॉर डॅमेजेस बट परमनंट इंजंक्शन नॉट टू डॅमेज द प्रॉपर्टी. भिंतीला मोठमोठाले खेळ मारून त्याची भोगदे पाडायचा. This is what damaging and wasting the property. It may cover anything. You have to point out that ultimately my property is being damaged and wasted. It may come under that particular case. When we say that, well, in alienation, you must have seen so many times in partnership, partition, several or specific relief act. Suppose a partnership firm is there, and there are 4 partners, 3 have formed the group, and for the last partner they say, don't enter into this premises, it is our business. What they are doing, transferring properties, selling goods, etc., one doesn't know what they are doing. He can ask for an injunction, or wrongfully sold in the execution of a decree. Property actually purchased by the wife. She is serving. Husband nominally doing some business, no income. From her this particular salary, installments are going on. I know it conducted, which went ultimately to the Bombay High Court. But in our country, still we people say that, well, women say, Pati Dev. Property was purchased in the name of husband. All money paid by the wife. There was no particular bar of Binami transaction act because property was purchased and he was accepting as an agent or a particular thing. Then he had taken a lot of loan from the bank. And one day the bank attached the property and he was not paying the amount, property was put to auction. That wife came to me. So do something. I filed a suit in the civil court, pointing out that the bank has no authority to attach and sell the property. Property belongs to me. It is wrongfully sold in the execution of a decree because the bank has obtained certain particular decree against them. I said, I am neither a borrower nor a guarantor, nor I have given this property in security merely because the property stands in the name of my husband. We pointed out all things. Ultimately, earlier court thought that, well, it is a collusive suit. But then we pointed out that it is not a collusive suit. Even relations strained. Matter had gone to the extent of asking for divorce, etc., etc. Otherwise, people can do anything to save this particular loan decree. I remember one bank came to me and they say that, well, sir, this is the property which was in his name. But now the property he has transferred in the name of wife. Then what happened? He said that, well, they have taken the divorce. And when they went to the search, they were residing under the same roof. Jagala divorce, घरात दोघं एकत्र. Saying that, well, माझ्या कुठे प्रॉपर्टी आहे, बायकोची प्रॉपर्टी आहे ती. बायकोने लोन घेतलेलं नाही, काही नाही, असे कोलिजिव्ह सूट असतात. But this is not the case where, my friends, and court granted an injunction. See, my friends, therefore, property wrongfully sold in the execution of a decree. But provided you must have a very strong prima facie case. You have to point out the source of money, etc., etc., everything, every piece of evidence, even prima facie. Otherwise, generally, court will not grant a particular injunction, that too also in execution of a decree, and that too also in a recovery of the amount, or enforcement of a decree. That will generally not happen. When I am going to point out lastly to that aspect. So, my friends, therefore, this is the second aspect. First aspect. Second, that will defraud the creditors. Property has been given in mortgage to the bank. How many mischief the defendants play? Just now I told you, they will try to transfer the property, etc., etc., etc. Certainly, court can even appoint a receiver, but that is not the subject. The court can grant an injunction. That is because property is being the particular transferred to defraud the creditor, so that amount should not. So that is what exactly I just told you that well. And therefore, you must have come across, and that is, my friends, Section 53 of the Transfer of Property Act. If there is a wrongful and transfer, even you can file a suit for a declaration to that effect also. Friends, therefore, a wrongful transfer, in order to defraud the creditors, a suit can be filed, and even injunction can be asked for, permanent injunction as well as a temporary injunction, during the pendency of the suit, no doubt. And the last is, we say, which I have told you so many times, that in our country we say rule of law, that possession cannot be taken without following a due process of law. What is this concept of a due process of law, which has been embodied in Section 6 of the Specific Relief Act? You can't take the possession. If the person is a settled possession, you can't take the possession by using the force. What is meant by due course of law? Following a due course of law, file a suit for possession, get a decree of possession and execute it. But if you are doing it otherwise, if the defendant is doing otherwise, then the plaintiff can certainly file a suit for particular simpliciter for permanent injunction. I am using the word suit simpliciter for permanent injunction, no declaration, etc., etc., seeking the relief that the defendant may kindly be permanently restrained from taking the possession without following a due process of law. Temporary injunction can also be followed on the basis of that. For example, tenant. I gave the example. He has not paid the rent. He is not using the premises for the purpose for which it was let. No doubt, landlord gets a right to file a suit for possession. Landlord may get possession by of a decree, but you can't remove him by forcible means. That is what we talk a due process of law. And accordingly, that particular injunction can be asked for. Now coming back to the point, my friends. I told you that, well, in case of temporary injunction, either party can ask for injunction. Even defendant. But the defendant can't ask an injunction in a suit filed by the plaintiff on the last aspect. Wording is, defendant is trying to dispossess the plaintiff without following a due process of law. That means only plaintiff can file a suit or ask an injunction on that count. If during the pendency of the suit, if the plaintiff is trying to dispossess the defendant, defendant has to file a separate suit. He can't make an application for temporary injunction saying that, well, my position may be protected. Because there is no power, source of power under section order 39, rule 1, subclause C. So that is what the position you have to remember that well. So he can ask, because wording in 39(1)(a), any party to the suit is trying to damage or wastage the property. So any party means defendant also comes in that case. So therefore that aspect need to be taken into consideration. This criteria we have seen. I told you that, well, generally temporary injunction has to be on the basis of permanent injunction. I told you section 41 of the Specific Relief Act, section 38 of the Specific Relief Act. So in normal course, if ultimately a final relief is not going to be granted by way of a decree, court will not grant a permanent injunction. A reported case. If the plaintiff is not entitled for permanent injunction, plaintiff is not entitled for temporary injunction. AR 1968 Bombay, page 282. A landmark judgment of our Bombay High Court. 68 Bombay, page 282. What has happened was, plaintiff filed a suit against the defendant, stating that defendant is carrying out the construction without getting the plan sanction or proper sanction. His construction is illegal, he should be restrained from carrying out the construction. Firstly, concept of locus standi may come. He is carrying out the construction on the property that is his own property. That is a matter between the corporation and the defendant. And plaintiff is asking whether such a permanent injunction can be grantable, and High Court says not. And if the plaintiff is not entitled for permanent injunction, that means ultimately he is not entitled for the final relief, court may not grant a temporary injunction. And therefore, still some particular lawyers commit mistake, we see, generally not but commit. They directly ask for temporary injunction. Arguments are there. Even there is a reported judgment of the Supreme Court. If you are not paid for a permanent injunction, how court will grant you a temporary injunction? In a suit for partition, you say that not to create third-party interest. All right. Temporary injunction application, defendant may kindly be restrained from carrying out any construction or changing the nature of the property. You are not even asked for a permanent injunction. Whether court will grant a temporary injunction. See, there is a judgment of Gujarat High Court, there is a judgment of Allahabad High Court, and one judgment of the Supreme Court. Find out that temporary injunction is always granted on the lines of permanent injunction and in the same manner in which asked for permanent injunction. So therefore, so many times it happens that even there is no prayer for permanent injunction while drafting the plaint, and then only temporary injunction application is made, these arguments will advance and will come against you, saying that, well, you are not even asked for a permanent injunction. Where is the question of granting a temporary injunction? Generally, I am telling you that way. So therefore, in that particular case, you have to take into consideration. But again, I told you section 94. You have to point out in order to prevent the ends of justice being defeated. And there was a Supreme Court to consider in 1962 Supreme Court that, well, even temporary injunction can be granted under section 151. There is a one injunction granted by the High Court under section 151, wherein application for temporary injunction was for not to display particular serial. They say they damage our particular emotions and etc. etc. Certain religious matters were shown. Now, not covered by Order 39 Rule 1. We saw clause A, we saw clause B, we saw clause C. Nothing is covered. And there was a contract not to display such things, etc., etc., etc. Injunction was asked for. Argument was there. It doesn't come any of the clauses of Order 39 Rule 1. Order 39 Rule 2 talks about the breach of contract governed by the Chapter 2 of the Specific Relief Act. So where is the question of granting that particular injunction? Where the court ruled that such an injunction can be granted under the inherent powers of the court, that is section 151. Read with section 94 in order to prevent the ends of justice being defeated, etc., etc. This is what the position is. Now, when you must have always consider this when we talk about that, when you consider temporary injunction, another criteria. First criteria I pointed out. Though Order 39 and section 38 are different, but still court does not grant injunction, I will be on the streets. Court has to grant an injunction. Otherwise, day after tomorrow, he will be nowhere in possession. Suit itself will become infructuous. Depends upon. So therefore, in that particular case, if the court wants to grant, because some of you become judge, then you have to know that, well, you have to give the reasons while granting a ex parte injunction. Reasons for dispensing with the notice. No doubt how that particular strong prima facie case is, but in addition to that, why you are granting an injunction without issuing a notice? Corporation says demolish it within 24 hours, without any notice, without being heard. Plan, sanction, everything. If you go before the court and say that, well, sir, see this notice, and it can affects on my particular conspicuous part of my house of my client, yesterday night only, and today in the morning I have come. If this court doesn't grant an injunction without issuing a notice, tomorrow it will be demolished. Depends upon the facts. In order to prevent the ends of justice being defeated. That is the ground to dispense with the notice. Normal rule is notice has to be issued. Suppose in case of caveat, now you know that your order 40A has been introduced, and even there are caveat rules of the framed by the High Court. And if you see the clause number 7 of that High Court rules, even injunction can be granted in spite of the caveat, but again in that case duty is cast upon the judge. He has to pass a speaking order and give the reasons why he is not giving a notice to the other side. But again, in case of caveat, in rarest cases, injunction is granted. Howsoever it may be, but still it can be granted in that case. So therefore, this is what we call a ad interim injunction, lasting till party appear, file say, an opportunity is given, and then temporary injunction in that progress. So that is what we talk about, ad interim injunction. This is what I procedure. Again, procedure you must find out, my friend, law develop on that point. Injunction has to be decided if you see the opening word order 39. When the plaintiff files suit on affidavit or otherwise, you can't convert the temporary injunction application into a mini trial. Suppose the affidavit has been filed, plaintiff comes, the defendant has an opportunity to file a counter affidavit. And when the defendant files a counter affidavit, if some new facts are brought on record, plaintiff can again file a counter affidavit to that counter affidavit with the permission of the court. Procedure is laid down in order 39 rule itself. And if we see the provisions of section 30 of the Civil Procedure Code, that wherein it is stated that, well, whenever the court can decide the matter, a particular matter, on the basis of particular procedure, this is affidavits, etc.,